You're coming down off Vail Pass when you see it in your mirror. The semi's been back there for a mile and it's not slowing down. A truck accident on I-70 in Colorado starts like that. One moment, everything is normal. Then the truck is in your lane and there's nowhere to go. Most people who survive a crash like that spend the next few days in shock. They answer the insurance company's call. They assume the driver is who they're dealing with. They do not know yet that the driver may be the smallest part of what happened. The trucking company may have known the brakes were failing. The maintenance contractor may have signed off without opening the housing. The black box inside that truck captured the whole sequence: speed, braking inputs, every warning light. That data is already on a deletion clock, and it starts running the moment that truck pulls away. The liability chain in a Colorado truck crash runs further than most people ever see. And the piece of evidence that controls all of it has a window measured in weeks, not months. If you live in Colorado and you've driven on I-70 west of Denver, you already feel the danger. The grades coming down off Vail Pass, the long descent from the Eisenhower Tunnel toward Dillon, the canyon stretch through Glenwood where there's nowhere to go if something goes wrong. Those are not just unpleasant drives. They're engineered danger zones for commercial vehicles. The Eisenhower and Johnson tunnels sit at over 11,000 feet, with approach grades hitting 7%. Vail Pass holds grades above 6% for miles. That is why runaway truck ramps are cut into the mountainside on those descents, and loaded semis on these grades sometimes cannot stop. Overloaded trucks running overheated brake systems on steep mountain grades is one of the most predictable failure chains in commercial trucking, documented in federal safety data year after year. When that failure hits a family in a passenger vehicle, it's not a simple two-car accident. It's a commercial liability event with multiple responsible parties. Most truck drivers are employees or owner-operators working under contract for a trucking company. The driver's employer can be held directly liable for negligent hiring, negligent supervision, and violations of federal hours of service rules, including for knowingly putting a driver with a dangerous record on a mountain corridor route. Then there is the cargo loader. On steep grades, improperly secured loads shift and create handling instability. If the cargo was loaded by a third party, that company can be named as a defendant. Then there are the maintenance contractors. Many trucking companies outsource brake inspections and certification to third-party shops. If that shop certified a brake system that was already failing, they share liability. Then there are the manufacturers. If a braking component had a design defect, that opens product liability against the manufacturer. What this means practically: a single truck crash can have 4 or 5 liable defendants, each carrying their own insurance policy. The Federal Motor Carrier Safety Administration sets the rules for commercial trucking, and those rules become the evidence framework in Colorado truck accident cases. Hours of service is the most commonly violated. Drivers are legally limited to 11 hours of driving within a 14-hour window, with mandatory rest periods. Driver fatigue degrades reaction time and decision-making at the same rate as intoxication. When data shows a driver was in hour 13, that is not just a regulatory violation. In a Colorado courtroom, that is evidence of negligence that shifts the burden of proof significantly. Federal rules require drivers to complete a daily vehicle inspection report at the end of each day's work and to conduct a pre-drive safety check before operating the vehicle. The documentation of those checks is part of the evidence trail. In serious crashes, those records often go missing or turn out to be rubber stamped without a real inspection ever taking place. Weight limits on I-70 grades are posted and enforced by CDOT, but overloading is common. An overloaded truck on a steep grade puts demands on the braking system beyond manufacturer specifications. Every one of these violations is documented somewhere. Finding that documentation fast and preserving it before it disappears is the job. Here's where the clock starts running, from the moment of impact. Most commercial trucks operating under the federal DOT requirements carry an electronic logging device. There are exceptions, including short-haul operations and certain older vehicles. But for the majority of commercial freight carriers on I-70, an ELD is required. It captures driver duty status, hours of service, and vehicle activity. That is a legally required record that carriers must retain for 6 months. But the ELD is not where crash event data lives. The engine control module, or ECM, is the truck's black box for the crash itself. It captures speed, braking inputs, GPS location, and engine diagnostics in the moments around the impact. That data operates on a rolling overwrite cycle specific to the device and the carrier. It can be gone in weeks. There is no automatic legal hold triggered when a crash happens. The way to preserve it is a spoliation notice, a formal legal demand to the trucking company, their insurer, and the relevant data providers to suspend routine deletion and preserve everything tied to that vehicle and driver on the date of the crash. That notice needs to go out as fast as possible, not a week later, not after the family gets out of the hospital. The sooner it goes, the better the odds the data still exists. I have seen cases where an attorney waited 2 weeks to send the spoliation demand and the data was gone. At that point, you're reconstructing the case from eyewitness accounts instead of hard, time-stamped evidence from the truck itself. Have you ever seen a runaway truck on I-70? Drop it in the comments. Some of the most dangerous situations I hear about come from people who drive those corridors every week. Commercial trucking insurance is structured completely differently from standard auto coverage. Federal minimums for property carriers transporting general freight start at $750,000. Carriers hauling oil or hauling hazardous materials face a $1 million minimum. The most dangerous bulk hazardous material carriers face a $5 million floor. These are the floors, not upper limits. A major trucking company operating on I-70 may carry $10 million or more in total commercial liability coverage. Here is what most people do not understand. The driver's policy, the trucking company's policy, the cargo company's policy, and the maintenance contractor's policy are all separate. When the first adjuster calls, they represent one layer, usually the driver's or the primary carrier's coverage. Settling with that adjuster does not close the other policies. Accepting a quick settlement and signing a release can prevent you from pursuing the rest. I have had clients sign a $50,000 settlement with the driver's insurer, not knowing that the trucking company carried $3 million in separate commercial coverage. Once you sign a release, that money is gone. And when the adjuster from that insurer calls, knowing what not to say matters just as much as knowing who to name. That is in a separate video on this channel. If you want to understand how Colorado courts calculate what a case is worth, from medical bills to lost wages to full pain and suffering, the case worth video is linked below. And if you're dealing with a truck accident right now, our contact info is in the description. Drop a comment. Have you ever followed a semi down Vail Pass? Tell me what you've seen out there.